Since your days at the bar, Lord Denning, the legal system has, of course, acquired a tremendous undergrowth in all the special tribunals and deciding bodies, many of which came along with the welfare state. And I think you've had a lot to do with them as a judge and with working out the principles on which the courts ought to control them, if indeed they ought to control them at all. And you yourself played a large part at one stage in your judicial career by being, I think, a one-man tribunal for war pensions.
Yes, well, that was the most important jurisdiction and the most interesting which I've had, I always think, because although during the war and after it, there were tremendous growth in tribunals without any appeal to the courts at all. Going back to quite early times, I think in the First War, there was, in case of pensions appeals, when soldiers or sailors were injured or wounded, they had an appeal to a pensions appeal tribunal, which had a legal chairman and a medical assessor and another, the assessor. And from that, there was an appeal to a high court judge on a point of law only. And it was a final appeal. I was nominated after this last war to be the nominated judge for pensions appeal tribunals, and there was no appeal from me, which it was I'm not sure how wise a position it is, but it enabled me, I always thought, to remedy, and I was very pleased to be able to do it, to remedy injustices which were being dealt out by the tribunals of that time to our soldiers and sailors who had been injured or wounded in the war. But it was this: they were putting the burden on the man, the soldier or the sailor, to prove that his illness or wound was due to war service or aggravated by war service. As I read the regulations and the War and Royal Warrant, the burden was on the other side. If the man was fit when he went in and unfit when he came out, they had to prove it was not due to his war service. And that principle, in my position as the nominated judge without appeal, I laid down. It meant that they had to alter their decisions and give them in favor of the men with hundreds of cases. In fact, they had to reopen. I said I would reopen them if they didn't. They had to reopen many past cases and give pensions to men which had been disallowed before. That was because I remember the government of the day, they would have liked to bring some influence on me to bear, thinking I was giving too many pensions. Others would think I oughtn't to give enough. But at all events, no minister or government need say a word to me. I was independent of them, and I decided those cases, I believe rightly, in favor of the men. Take cancer, for instance. They don't know the cause of cancer. Was it attributable to war service or not? If there had been an indication in the reports that there had been x-rays, this man had been subject to x-rays, and those might have caused it, I would hold it. They rejected the appeal time after time. I held that that might well be a case a man was attributable to war service, and we give him a pension. Now, of all the jurisdictions which I've exercised, I'd like to think that was as beneficial as any which I've exercised without appeal. That was because there was a right of appeal to the court, to a high court judge, on a point of law. But mark you, I could stretch the point of law, stretch it so widely that it would extend to many questions of fact as well.
So you were a kind of one-man House of Lords. I rather suspect that that's a position you would have liked to occupied since.
I don't know,
but at any rate, you
been criticised often. They often say, oh, well, that's wrong. Just one man's idea of justice is all wrong.
But, of course, there's the other side of the picture. Many of those tribunals which came in with the welfare state operated under Acts of Parliament which gave no right of appeal at all. And it wasn't until the right of appeal on a point of law was greatly broadened by the first Tribunals and Inquiries Act of 1958 that there was a general right of appeal on a question of law. That was done as a result of the recommendations of the Franks Committee. Wasn't it about that you made your maiden speech in the House of Lords?
Of course, I knew all about it. I'd given those Hamlin lectures in which I drew attention to the fact that these tribunals, they'd been set up before the war and during the war. There was no appeal from them unless they went out of their jurisdiction altogether. No way of putting them right at all. And I mentioned this and drew attention to the iniquity of that in my first Hamlin lectures. We gradually got round it a bit from Lord Goddard's case for error of law on the face of the record. That was altogether too limited. And then I remember there was the Administrative Tribunals and Inquiries Commission. Sir Oliver Franks, now Lord Franks was the chairman, very ably assisted by the future Lord Chief Justice, Lord Parker, and those two, in their very important report about 1957, recommended there should be an appeal. They went through all the tribunals, recommended there should be an appeal on points of law from tribunals, recommended also about inquiries. We'll deal with those later, about reports and so forth. But those recommendations were about 1956 and 57. And as it happened, I was appointed a Lord of Appeal in 1957, and this bill to implement the recommendations came up in that year I was appointed. I made my maiden speech in November 57, I think, soon after I was made a Lord, and I took as the subject, but the motion was before the House, administrative tribunals. Lord Reading, Queen's Counsel, took a very leading part, and I made my maiden speech upon it, saying how important it was that these recommendations should be implemented, and they were implemented in the Tribunals and Inquiries Act of 1958, which is a landmark in our history on this matter.
That act put a good deal of force behind the right of appeal, because it also contained a requirement for giving reasons, so that once you can get at the reasons which underlie the tribunal's decision, then of course you know what is or isn't wrong about it, and you've got a basis on which to appeal. So those two things seem to go hand in hand. And as you were saying earlier, there's nothing so salutary as an obligation to give reasons to make a tribunal really think its decision through.
Yes, well now, that act covered many grounds. It firstly said we weren't to take any notice of previous acts which took away any appeal or said there'd be no certiorari. We abolished they abolished any previous restrictions on the appeal. It went through a whole list of tribunals in which it said there was to be a right of appeal automatically on a point of law. But then I'm dealing with tribunals, not inquiries at the moment. But then you're quite right about reasons. I had tried in one or two cases to say that we could order a tribunal to give reasons. That hadn't been taken up generally. The reason I wanted to make them good reasons was because then I said they were making an error of law. I could look at those reasons. See, they're making an error of law on the face of the record. I could look at those reasons. So I was all in favor in one or two cases of saying, well, they ought to give reasons and we could order them. But that was all remedied by the act itself, which said they were bound to give reasons. And I'm glad to say, and I've seen many of them since, those reasons given by tribunals, maybe industrial tribunals, dealing with all nowadays with all the employees claiming for wrongful dismissal and unfair dismissal and the like, and all the tribunals up and down the country, and they give their written reasons, and this is of the utmost value, not only to an appellate court, but to the individual who's had his case dealt with. If he's had proper, satisfactory reasons given to him, he'll take it. If they're unsatisfactory, he can bring it on appeal.
So that gave much wider rights of appeal on a point of law. But then there's the question, what is a point of law? There's the facts, there are the inferences of fact drawn by the tribunal, and there are the rules of law. Where do you draw the lines there?
There you're touching upon the neatest way in which, if I may say so, we've extended the right of appeal. The statute always says you can appeal on a point of law. And then we've got the argument, what is a point of law? You know, we've got round that. If the tribunal decided without any evidence to support it, going on no evidence is a point of law. If they come to, on the facts, to an utterly unreasonable decision, that's a point of law. Of course, if they interpret a regulation or a statute wrongly as we think, that's a point of law. In other words, we've extended the point of law and the meaning of it so much as to get virtually an appeal in every case where justice demands it. I'd like to think that. In other words, by a process of interpretation, application, the judges have extended an error in point of law to include, in truth, many errors in point of fact.
I think you gave an important decision in a planning case, or perhaps a compulsory purchase, about a house which the question was whether it ought to be left out of the compulsory purchase order. And that could only happen if it was in good condition and it was desirable to do it. And I think you held that there was no evidence really that had been submitted to the inspector which justified reaching that conclusion, and although it was purely a finding of fact, you could set it aside. That seemed to open a new chapter in the court's powers to review conclusions of fact.
Yes, because that reminds me of that case. In a lot of these planning acts and so forth, there's a provision you can go to the courts if they go outside their powers or do something not authorized by the statute. And it was argued before us that it didn't extend to errors of the kind you were describing like that. And I remember I can see the difficulties technically in getting around the words of the statute, but fortunately, Sir Gordon Slinity now was, as he now is, was what we call the Treasury Devil. He's the junior lawyer, barrister, who advises the government on all these matters. And then he made a concession and admission, which really I thought was most valuable, and I took up at once. If the tribunal or body, whoever it is, acts without any evidence, or acts perversely in the face of the evidence, or does something so unreasonable that no reasonable man would come to it, in all those cases, that's an error which the court can direct. I think that was the Ashbridge case, but quite recently, I think it's virtually, not in terms, been virtually approved by the House of Lords. I expect you would remember it. The House of Lords had a big discussion on what's an error of law and what's an error of fact. It's a case I always remember, but Edwards and Bairstow. I'd like to think I'd shown the way to it in an earlier case. But the House of Lords then said that if a tribunal or a lower body, that was some Inland Revenue Commissioners, if they come to a decision which is so unreasonable that no reasonable person would come to it, that's an error of law. And I was delighted with this, because virtually many of errors we can put into that category. So unreasonable that no reasonable man could come to it.
That's very nearly saying that if it's a decision that you disagree with.
Well, it is the case. So the judges have to be a bit careful. They mustn't overstep the mark, because, and this is rather important for the students or anyone to know, when you're deciding whether an action is reasonable or not, there's a band within whichever course you take may be reasonable. For instance, whether it was in particular about a child case, giving custody or to one parent or the other, it's got to come to a reasonable decision. Well, the reasonable decision might be to give it to one parent, but an equally reasonable decision would be to give it to the other parent. And no one could say that the tribunal was wrong or unreasonable, whichever way it come to, because Lord Hailsham said this, there's a band of reasonableness. You can't say it's unreasonable to come to either of those decisions. But outside that band, then the courts will always interfere. If it's so unreasonable that no unreasonable man can afford it. And that's the big criterion, which goes back to Lord Green in the Wednesbury Corporation case. All the students and everyone must know about that. That was a case of license to a cinema for youngsters, going back to 1948, or maybe before, 1944, I think it is. But at all events, which every student and everyone ought to know, that if it comes to a decision which is so unreasonable that no reasonable, I'm using the formula, so unreasonable that no reasonable person could come to it, then the courts will set it aside.
Perhaps we could pass easily now to public inquiries, because the same ideas play a prominent part in that context. That's to say, the value of seeing the recommendations that the inspector has made after the inquiry, and of seeing the decision letter that goes out from the ministry deciding the case. You will remember very well how in the days before the Franks Committee, those documents were not made available to the person whose land was being taken or whose planning application was being refused, and he had very little idea what had been going on. Then it was all opened up by the reforms of 57 and 58, and has been brought out into the open. And then the courts, in your court on many occasions, decisions of ministers were questioned on the documents which were now available. Everybody could see the inspector's report, and they could find out if there was anything wrong and could have legal remedies.
Well, that goes back to the great case of the Stevenage case, you know. I think it was the late Lord Silken with his town planning scheme, a new town planning, new for Stevenage.
Okay.
And then there was the public inquiry about it, and it was thought it was, and the minister gave his decision. Lord Silken, there was to be the now plan for Stevenage. But no reasons, no report, just the decision of the minister. And when objection was made to the courts about it, the House of Lords wouldn't interfere, and Lord Silken, I think, said, oh, it was just a chance for them to blow off steam, decision already been made. And that's the objection which was made. You know, all these new roads, the one round Winchester and all, we've had the big, whatever it is, round London, M25. They've had these road planning inquiries, whether there should be a new road or not. Objections are allowed to appear. And what the big objection was for all the objectors was, this has been already decided by the Parliament, by the department. And putting up an inspector is just really for just blowing off steam. The decision's already been made. And that's been the big controversy over the years. Now you're right. As a result of that Lord Franks' inquiry and the Act, there has to be a report of the inspector which has got to be available for both sides to see. The minister gives his decision letter in which he gives his decision, and then in a proper case the citizen can come to the courts, and he has done in many cases before our land, to say the decision was wrong in point of law or erroneous. I remember just before I retired, we had a big case from South Wales in which there'd been the inquiry and all that, but we overruled the minister in regard to compulsory purchase of land because he said we hadn't taken the right considerations into account. So there's a very important safeguards made in regard to these statutory inquiries.
Of course, the right of having an inquiry can be abused occasionally, and I think you've had cases before you where there has been misconduct or a row kicked up or some trouble made in the inquiry, or perhaps some pertinacious objector who has tried to use the procedure to block some plan which perhaps new roads or something like that, where it has caused unjustifiable delay.
Yes, well, now, that is a very important point. Well, you will remember, and we all remember, there was a gentleman once who took such objection to these inquiries, think that they were all decided beforehand, that he didn't took objection to the inquiry starting at all. And they were very active protests, well-meaning protests, very active protests, so the inspector couldn't get down to his evidence or do the work. Well, I deplored that at the time. I've deplored that in other cases, because I think we ought to give credit to the inspector and the ministry having a public inquiry to hear all objections and give a proper report upon it. So I deplore all those, but you do find the objector who feels so strongly about it, he'll take all sorts of maybe technical objections. If so, we hear them. Technical objections. There was a very good lady, Miss Lovelock, who had a nice piece of land near the green belt, and it was going to be overridden by one of these new great circular roads around London. Well, she was absolutely justified, thought, in taking every possible objection she could, and she did it very well, and I complimented her upon it. Unfortunately, she lost, but she took it very well. She did a good deal herself. She lost because if you look at it from the wider point of view, it was most important that there should be this circular road, this M25 around London, and though it did encroach on the green belt a little, nevertheless in the great public considerations, that was the right decision. But there, I sympathized with Miss Lovelock. We listened to her all. We gave her every help in a way we could within the law, but we couldn't help her further.
Well, of course, the law about inquiries and the whole system of inquiries is very elaborate. It consumes a lot of time and money. Do you think, in the light of your experience, that it's working satisfactorily?
Well, I can't say that. It's a very big question. These planning inquiries and planning departments, they have a whole team of planning inspectors who hold the inquiries, and they make their reports, I think, very well, but it takes a long time. Schemes, development can be held up for a long time, planning appeals and on. But I think it's a very difficult question. Whether any new system could be, a better system could be devised, I don't know. They've done a good deal by allowing a good deal of devolution from the minister or from the county council, no, from the urban district councils. They've allowed a good deal of delegation like that. But it's the most difficult subject to handle or to deal with. I wouldn't say it's unjust at the moment. I think all the planning authorities do their very best to decide rightly, but we must still keep, as far as we can, it's subject to the rule of law.